So the first part is situating. It's the part of the book I find most engaging. And so I'm going to take about 15 minutes to situate his situating, and then talk about some of the things he thinks are problems in discourse about natural law, again, circa 1958. And then I'll stop and we can see what kind of discussion we can have on Zoom. In 1937, the Walgreen family, yes, from the pharmacy, the Walgreens endowed the University of Chicago program on the study of American institutions. It was a program to foster among faculty and students appreciation of American institutions and values. After World War II, they decided to create a Walgreen lecture series. And in the foreword to that lecture series, the Walgreen Foundation laid out, democracy, I'm quoting, works, it's true. But so did fascism until it was destroyed from the outside. The need for a philosophy that shows democracy to be grounded firmly on rational principles, this need is apparent, unquote. So with all good tribute to the University of Chicago, the Walgreen family founded a lecture series with a very tall order that the inquiries and arguments be both true and persuasive. And especially noteworthy is the fact that the first 4 Walgreen lecturers really ramped up the natural law and natural rights issue. And remember, this is right after the war. So 1948, Yves Simon, our author, whose lectures were published under the title Philosophy of Democratic Government. Number 2, 1949, Leo Strauss, Natural Right and History. 1951, Jacques Maritain, Man in the State. And 1952, Eric Voegelin. It's basically the new science of politics. In retrospect, it's not surprising that the post-World War II era becomes one of those periods of time in which there is a lot of interest in natural law and natural right. The great theologian Karl Barth described that era immediately after the war as the time of disillusioned sovereignty. And one reaction through this disappointment about the behavior of nations and government was existentialism. And of course, the existentialist response to the disappointed sovereignty is, well, sovereignty should be handed back to where it first belonged to begin with, which is the will of the individual, who can make himself to be what he needs to be. Thank you. However tragically that turns out. But another response to disillusioned sovereignty was to bring a moral argument to bear upon the post-1648 European experience. 1648, of course, Treaty of Westphalia, in which a large part of Europe was divided geographically according to the principle of sovereignty. Undivided, perpetual, absolute power, at least over a certain geographical region. To call post-1948, 1945 disillusioned sovereignty has another kind of very prescient connection to that history, because almost immediately after Westphalia, give a generation or two, began the era of revolutions, all of which made natural law an emblem, a flag of the revolution. That would be 1688, the Glorious Revolution, 1776, the American Revolution, and 1789 in France. And doubly interesting is that those revolutions were all fought against absolute sovereignty. And so absolute sovereignty has quite a history of inspiring and sparking natural law thinking. And it's especially aimed from the 16th century, 17th century, all the way to the post-World War II era at executive power. Executive power almost always is the target of politically charged and morally charged natural law and natural rights arguments. By the way, this is probably true all the way back into the ancient world, when Nero and Pharaoh and other such figures become the target of natural law complaints. Executive authority was a huge problem post-1945. It's complicated by the fact of the executive branch became the vehicle of the ideologies. So in Germany post-1933, it was the executive branch that ran the government, no longer the parliament. And the executive branch basically became the public face or the political face of the party. So in both fascist and in communist governments, the party capture of the executive branch summarized the meaning of the government. And many of these regimes really did try to play the role of philosophers. Executive philosophers loaded with guns and surrounded by police. It was the place, it was the place for propaganda and control of education. Post-1945, after this experience, there was a very strong presumption around the world, but especially in the Northern Atlantic region, that laws be just and that executives be put under the rule of law. And the question was how to do that, because they had already had experience with constitutions just being rolled up and defeated by governments. They were leery of legislative branches, unlike in the 17th century when the legislative branch was usually the leader of the natural law argument party. But post-1945, they were very leery of legislative branches, which seemed totally unable to inhibit the rise of the totalitarians. And so there was a drift, but it was a strong one, and many people shared it, toward constitutional law, bills of rights, international charters, and courts. That is, if natural law is to be revived, natural right is to be revived, and if it becomes part of a philosophical check upon unmitigated sovereignty, courts will be the best vehicle for this. And my favorite example of it is in 1943, so a few years before the war was over in the United States. A very important decision, the West Virginia against Barnett. Justice Jackson, Chief Justice Jackson, wrote the opinion why the US Constitution forbids compulsory flag salutes in public schools. And here are a few sentences from that decision. Nor does our duty to apply the Bill of Rights to assertions of official authority depend upon our possession of a marked competence in the field where the invasion of rights occurs. Sure, the task of translating the majestic generalities of the Bill of Rights, conceived as part of the pattern of liberal government in the 18th century, into concrete restraints on officials dealing with problems of the 20th, is one to disturb self-confidence. These principles grew in the soil, which also produced a philosophy that the individual was the center of society, that his liberty was attainable through the mere absence of governmental restraints, and that government should be entrusted with few controls and only the mildest supervision over men's affairs. We must translate these rights into a soil in which laissez-faire, where the principle of non-interference has withered, at least as to economic affairs and social advancements, and increasingly sought through the closer integration of society through expanded and strengthened governmental controls. But we cannot, because of our modest estimates of our competence in such specialties as public education, withhold the judgment that history authenticates as the function of this court. Now, you should read the whole thing, but it's a wonderful statement of Simon's era, at least on American shores. Right. Number one is that there must be a proper moral understanding of the limits on government, and not just institutional limits, but moral limits on government. They should be apparent in the Constitution, and that when the time was right, the timeliness, when history demands it of an institution, it must step forward with that kind of an argument again. That by the way, Justice Jackson goes on to be the chief American prosecutor at the Nuremberg trials, post-1945, where he developed the prosecution strategy of prosecuting some German officials for crimes against humanity. So this is also an era, a few years later, of the 1948 UN Declaration of Human Rights. Right? By the way, the team was led by a Catholic named Charles Malik, who studied St. Thomas and Heidegger. Jacques Maritain, who was not in the drafting committee, but in a different committee just adjacent to that committee, Jacques Maritain called for the development of a practical ideology. Maritain was one of Simon's best friends. And I think the reason ideology comes in is because of that comment, which Maritain makes again in his 1950 Walgreen lectures. A practical ideology, namely, we may not be able to spell this all out philosophically, and we may not just by discussion come to a theoretical consensus of the ground of human rights. But we all believe it's true. And we believe it's true because we just went through a horrible experience and our moral sensibilities are properly attuned to the timeliness of this. The issue of timeliness comes up again. But in the final draft of the Declaration, the word natural was only used once in connection with the family. It says the family unit is the natural unit. They would have even eliminated the word natural were it not for the fact that Eleanor Roosevelt intervened to put it in there, to strengthen what she thought was family rights. And she knew exactly what word to use, which was the word natural. But otherwise, the drafting committee just simply, they had, after their first 2 or 3 drafts, they had a couple of thousand proposed amendments of that thing. And anything controversial, philosophically or theologically controversial, had to be taken out. And it was not a binding document. And it wasn't until 1966 5 years after Simon died, that they got around to making a binding document, and they discovered they couldn't do it for the very reason that goes back to 1948. They couldn't agree. And so they created two covenants. One is called the liberal covenant. It has to do basically with things like rights of due process, property owning, et cetera, et cetera. And the other document is more economic and cultural, corresponding to what we today would call social justice. So when Maritain was giving these lectures, it was Simon. It was also apparent to anyone who was paying attention to this stuff that it was 10 years and they hadn't come to a binding agreement yet. So that's on Simon's radar screen. And in the very year that these lectures are given was the election of Angelo Roncalli, who becomes John the 23rd, who 2 years after Simon's death publishes Pacem in Terris, which goes on to list 25 natural rights, human rights. They're all natural rights for John the 23rd. And so John the 23rd had no problem making up for the reticence of the UN Commission. And they're just listed, 25 of them. I mean, no church document had ever seen anything like that before. So it was a high tide of interest in and discussion, natural law, natural rights. Right? Simon, I believe, of all of the important and well-known neo-scholastic thinkers, was by far the most wary of all of this. He begins expressing his wariness back in the 40s. By the way, other Catholics in the late 60s become wary, but that's because of the sexual issues and the encyclical Humani Vitae. And then all sorts of people become wary of natural law arguments for a completely different reason. But Simon was tracking this from the very outset. One reason is that his specialty was philosophy of practical knowledge. And here, just to summarize, and not even to try to summarize, just to pinpoint one thing, Simon held the position that most neo-scholastics held, but he really emphasized it, that most of practical knowledge falls under prudence, not law. Okay, so the perfection of practical reasoning is not law, but it's prudence, being able to know the adequacy of the singular act and decision, to know it in its contingency. Whereas law tends not to know things in their contingency or in their universality. That's why we talk about not the prudence of gravity, but the law of gravity, right? So his first reason was he was getting the creeps, so to speak, that so many eggs of Catholic moral philosophy and theology were being put in the domain of law. But second, he was also becoming very uncomfortable with the issue of ideology. I think that's due in part to the fact that his friend and mentor, Jacques Maritain, was using that term. And we can't agree on everything, but we can agree on everything but the philosophy. And Simon said, well, this looks an awful lot like an ideology. And we should pay careful attention to it. Because as anyone, well, as all of you know, to try to give a philosophical account of a subject is much more difficult and will attract much less attention than to give a political account of the same thing. Give a political account and everyone's listening, right? This is why the cover of Leo Strauss's Natural Right and History and the cover of John Courtney Murray's We hold these truths. What was on the cover of those books? The Declaration of Independence, right? I remember a callow undergraduate at Notre Dame all those years ago being asked by a professor who saw that he was holding Leo Strauss's Natural Right in History, "Why are you interested in that? Are you a philosophy major?" And he said, "No, but I'm really interested in the Declaration of Independence." These are the kind of things that were going through Simon's mind. And his students at Chicago, particularly in the Committee on Social Thought, kept on saying, you've got to give a course on it, which he did winter term 1958. Okay, so let me say something about ideology. How far are we? Okay. He starts by saying, if you look at the issue of natural law historically, there's a remarkable diversity of historical context and accidents that go on in this history. All kinds of wonderful paradoxes. For example, well, he gives an example at the very beginning, that in the golden age of sensationalism in philosophy, that is building everything off of sensation, which is not Aristotle, was also the classical modern golden age of natural law theory. Go figure. That Locke, who was a kind of sensationalist, would write one of the most important treatises on natural law and natural right. And these kind of paradoxes crop up all the time, that the perceived importance of the topic of natural law and natural right doesn't necessarily track people's philosophies, and sometimes can be quite at variance with them. Okay. And Simon gives at the outset a kind of common sense reason why that's so, is that the issues of natural law and natural rights will tend to crop up in the public domain in connection with tragedy. Yeah. Crisis and tragedy are a good context for focusing people on these kinds of problems again. And he thought that's why it'll probably be impossible to completely extract the philosophical components of natural law from their historical accidents, because not even philosophers can completely restrain the impetus to look at this issue in terms of what's close at hand, like the Holocaust or whatever. And so, and by the way, he notes that in the history, and I think he's speaking here mostly of the modern history of natural law and natural rights, he says, notice that most of the people who write the books about this are either lawyers or politicians. He said, it makes sense, because they are the ones who want to change things, or they're the ones who are leading, trying to achieve some kind of consensus of response to social meltdown or whatever. So I'm going to mention three things, and then we can open it up. I think there are three aspects of ideology in connection with natural law that Simon spends a bit of time with. The first is at page 17 and following, but it keeps on bouncing around in later discussions. That as a system of propositions, natural law doctrines tend to represent the aspirations of a society. He calls them utilitarian, social, and historical aspirations. That natural law discourse has utilitarian, social, and historical functions, let's say. I call this, which Catholics in the group will be able to identify with, the signs of the times criterion. That is, they're propositions that may turn out to be true. And they may turn out to be perfectly congruent with a properly philosophical account of the same topic. But the propositions will tend to be overwhelmingly representing aspirations. By the way, that was right in Chief Justice Jackson's remark that I just read to you. You place a problem in history and you report your historical aspirations and the historical aspirations of your society, and usually report them under some aspect of urgency and timeliness, right? The more timely it is, the closer it will gravitate toward ideology for Simon. And timeliness usually is tied pretty close to threats to society. Okay. Second, which he reports at page 18. It always takes the appearance of philosophy. That is, I mean, all philosophical argument of a certain sort is going to begin, as Aristotle said, it's going to begin with doxa. It's going to begin with opinion. And of course, as Aristotle suggested, you have to get the best opinion you can find. In other words, a good starting point about a particular issue is what smart people or wise people have to say about it. And, you know, that was very much in the Aristotelian method to do a survey of, before we reach a definition of something, let's look around and see what so-and-so has to say about it, or so-and-so, right? True opinion, something that's quite likely to be true opinion is a good starting point. And number two, it will fall to the philosopher, usually dialectically, to begin working on that to achieve the beginning of a definition. It may start off only as a nominal definition, but it should move steadily toward an essential definition of the subject, right? And he says that the tribute that the more ideologically inclined thinkers pay to the philosophical moment is that they do want to imitate philosophy. So they will not begin with just anyone's opinion of, we hold these truths, right? They'll go to Jefferson's or to Locke's or to whoever might be judged as a good starting point for approaching the subject matter. And the problem here is when discourse and inquiry into natural law is primarily having this kind of sociological weight, to use Simon's own terms, that moment, that's kind of the proto-philosophical moment, gets left behind very quickly, right? And you develop just what you need, usually in speech, to form a consensus about how to meet the emergency. So for Simon, the philosophical moment might begin in an emergency or in some kind of an urgency but it moves under its own light to what is true, what is objectively true. In other words, it's capable of extracting itself from the emergency and looking at something just qua true, and on what basis, and with what qualifications and distinctions. And Simon says, of course, the virtue of philosophy is to transcend need, except for the need to know. It transcends need, social need, legal need, even moral need to some extent, right? But when natural law, natural rights, when that flag goes back up in urgency, it stays in the mode of need, and the subject matter is described chiefly in relation to our need for it, or its utility for us, not for what it is in itself. And therefore, there comes to be very little patience for definitions, distinctions, or for someone saying, I don't know, or this is not clear, or we may be wrong about this, right? Who wants to say they were wrong about we hold these truths, or there's something unclear about them? The third, which he raises pages 39 and 40. And because these kind of practical arguments are never totally successful, right? Human society is changing all the time, and none of this is writ in stone. It's kept alive by cliche. Now, albeit some cliches are much more important in organizing societal consensus and affections of society than others, but it will tend to keep going by cliche, which Simon says is quite obnoxious, right? So those are the three kind of problem areas, noting, however, that Simon does not believe it's possible or even desirable to entirely extract the subject from threats, needs, griefs, aspirations. I think he's just an old-fashioned philosopher. He does believe that some people should do that quite a lot, though, extract themselves from that. Should stand back and go, we haven't figured out what this means correctly, or we haven't figured out how to say it correctly, to stand back from the immediate job of forming a consensus